Happy holidays once again to all of you out there, and thanks for taking some of your holiday time away to spend with me here at Brother Counsel Studios, where despite the very busy holiday season, we are still cranking out the content that you have come to expect and enjoy. Well, today is going to be, I think, a very exciting day for all of you. The reason is that you know that if you've been following my coverage on the Karen Reed case, that I watched every single minute of the trial, and I felt that the Commonwealth did not meet their burden of proving beyond a reasonable doubt that Karen Reed committed this murder. And what really did it for me, and as all you know, if you've been following, what really did it for me were the ARCCA experts. Yes, I did hear Lucky Law Firm's testimony. I did hear Dr. Marie Russell. But what really, to me, was the nail in the coffin in the Commonwealth's case were the ARCCA experts. And therefore, after hearing that, that was really when my decision was made that the Commonwealth just simply did not prove their case beyond a reasonable doubt. So I've been offering other attorneys to come on and explain to me if they believe that Karen Reed should have been found guilty despite the ARCCA experts to try to convince me of that. Let's lawyer to lawyer talk about it. You all know about that already. And I haven't had anybody to take me up on the offer. But I didn't even know how many lawyers out there exist that would agree that she should have been found guilty. So I was sent the Prosecutors podcast, which I'm going through now. I did a number of videos on that. If you haven't seen all those, definitely go check that out. We spoke about Dr. Marie Russell, what they have to say about that. We spoke about what they have to say about Lucky Law Firm. I give you maybe a different perspective, different analysis. But today we're going to be talking about their analysis on the ARCCA experts, which again, this is very important. Maybe they will change my opinion. Maybe their analysis, these are Harvard and Yale grads. Maybe plain old me will be convinced by their analysis. So before we do, though, I do want to make a mention that someone did send me, and I appreciate this, somebody did send me a list of the attorneys that they believe have come out and have opined that they believe that Karen Reed should have been found guilty. So these are the attorneys, David Ehrenberg, Rick Schillenstein, Niyama Ramani, M. Torrin Gaffney, Alice Lacker, and Brett Talley, who are both prosecutors from the Prosecutors podcast, and Nancy Grace. So if any of you have seen any of these videos or heard these podcasts, and you can direct me to the specific video or podcast where these other attorneys lay out the case, why they believe, despite watching the entire trial, why they believe that Karen Reed should have been found guilty and the Commonwealth met their burden, I would really enjoy seeing that. Maybe they'll change my opinion. Who knows? But I definitely like to see what these other lawyers, trial lawyers, have to say about the evidence and why they came to their conclusions and opinions. Okay, but for today, we are going to be jumping into the Prosecutors podcast, Alice Lacker, Brett Talley, Harvard and Yale grads, and see what they have to say about the ARCCA experts and why they believe that they were not convincing enough to bring this to at least a reasonable doubt whether Karen Reed committed this murder. So here we go. Let's start.
Next is Dr. Daniel Wolf. Dr. Wolf works for ARCCA, which is an accident reconstruction firm that was hired by the FBI to look into the crash during their investigation of the handling of the case. We'll get back to this later, but I still don't really understand why the FBI was involved in this case. But nevertheless, although the jury was barred from hearing about this investigation, it did allow the defense to note that they had not hired or paid ARCCA for their work.
So the jury was not allowed to hear that the FBI was involved or the DOJ was involved, and they were this entity that hired ARCCA. And now this is a very important fact, and I probably spoke about this a number of times before, but the fact that you have an expert who was not hired by you to come testify is extremely, extremely valuable. Any trial lawyer knows that you've got to hire your experts. The other side's got to hire their experts. And the very common line of cross-examination is how much are you being paid by the other side? And you argue to the jury that these experts are not believable because they are just hired by this other side to say what they want. And obviously these experts are biased, they're prejudiced, they want their side to win so they can continue getting this work and getting money for their expertise. And therefore that's a very common argument that you make to the jury. Now in this case, these experts were very clearly not hired by the defense. So right away, that should boost their credibility right away. And if the jury only would have known that they were hired by the FBI and the DOJ, that may have done it for the jury as well. Okay, but they weren't allowed to hear about that for whatever reason. So now we have this completely independent, objective experts looking at this case, and they're going to give their opinion. So let's see.
In explaining his findings, Wolf said that, quote, assuming a pedestrian is positioned in a normal upright position, you'd expect to see more damage to the bumper. He noted here.
Now, that's true, that he said that if the pedestrian was hit straight on, you would find more damage to the bumper. But he also very clearly said that even if he was standing with his arm stretched out, and this was a side swipe, which is the common law's theory here, that the car was backed into him with his arm stuck out, he also said that there would be more damage to the car. So it wasn't just if this was a head-on collision. This is also if his arm was stuck out in exactly the common law's theory. His testimony was that there would be more damage to the car. So let's just make that clear.
That the damage was isolated to the taillight and some surrounding areas. Because there was a broken glass at the scene, ARCCA used a pressurized air cannon to fire a similar object at a taillight to create that similar damage.
Now, that similar object that she's talking about is not a rock. It's not any other object but a drinking glass. Like the very similar drinking glass to what John O'Keefe was holding. So it wasn't just a similar object, it was a drinking glass. Now maybe there's some slight differences between the two of them, but just to be completely fair about what he did, that is what it did. They fired a drinking glass.
Wolf said that striking only John's arm would not cause him to travel 30 feet. Then on cross-examination, Wolf acknowledged that it was common for shoes to come off in a pedestrian impact. John's shoes came off in this impact.
Yes, he did say that shoes can come off in a pedestrian impact. As he explained, if this was a side swipe impact, then you would not expect shoes to come off in this pedestrian impact. If this was a side swipe, which again is the theory of the Commonwealth here. So he debunked that theory pretty clearly.
Or John's shoes came off here. Wolf talked about the limited information he was given at the beginning, what I just said about experts, saying that, quote, there was nothing in the material that indicated the questions we were to answer. He'd never physically viewed the SUV, even though it was available for inspection. And by the way, he was hired to do reconstruction of the accident of this car, but he didn't look at the car. Wolf acknowledged that where someone was positioned when they were struck would have a definite effect on their injuries. Paging the pathologist. Remember, this is what we heard from the prosecution's pathologist. He wasn't aware that Reed said she hit him or may have hit John, repeatedly, too many people testifying to her saying this. And he didn't know that John's DNA was recovered from the broken taillight. And he didn't know that taillight pieces were found on John's clothes. He didn't.
Okay, so let's talk about some of this, because this is really a favorite argument that the side that believes that Karen Reed should have been found guilty always talks about. They always talk about, well, they had such limited information. The ARCCA experts had such they barely had any information. And they're just coming out with opinions, even though they're independent and objective. They're just coming out with opinions to help Karen Reed because they just simply don't know what they're talking about. They just don't have enough information. And therefore, these objective, independent experts are just talking from nowhere. They're just not using their brains. They're just not smart enough, and they don't realize what information that they actually need in order to come to an independent, objective opinion. Okay, so let's just talk about that for a moment. Okay, so first of all, if you're just watching this trial and you're a casual observer, you're not really used to trials, this is, again, a very common line of cross-examination which you employ when you're cross-examining a witness, which is, of course, what Lally does, because it's what you have to do. But if this worked on you, well, then this is why we do it. Okay, because this works apparently on some people, and it shouldn't work on lawyers, but I guess it works on laymen for sure. The idea is that you're trying to show everything that the expert didn't have, right? So, what can we show when this is just basically what can we show that the expert did not have? And even if the expert tells us it's not important, we're still going to argue to the jury that it was important, right? So here, very clearly in their materials, they've said they had everything that they needed in order to come to a conclusion. That's what the experts said. Now, as lawyers, that if that doesn't help you, well, then you got to argue against it. And you got to come up with some reasons why these people would not be forthcoming and honest. Now, like I said, that's much harder when this is an independent, objective expert as opposed to being hired. If they're hired, then you say, yeah, they're hired by those people. So therefore, those people, that side, only gave them specific information that's going to help their case. But here you have an independent body that's hiring them, the FBI and DOJ, and you would think that these people, or this independent, they want an honest answer, so they're going to give everything that's necessary to come to a conclusion. So that argument doesn't work as well. Now, even when, as lawyers, this is just, like we said, a common cross-examination technique, you always try to show what the expert did not have. And if you think about it, just logically, you think about it, you can start saying, well, there's a whole list of things they didn't have, right? They didn't have the transcript of Jennifer McCabe's testimony. They didn't have Carrie Roberts' testimony. They didn't have, Lucky Laughlin's testimony. They didn't see Lucky Laughlin's plow. They didn't know that he banged into a basketball hoop, and they didn't know, the videos from the waterfall and CF McCarthy's, which was also a question that was asked. You didn't ask to see those videos. Why didn't you see those videos? So this is more stuff that you were missing that you could have had, right? You could have had all this information, and you chose all this list of things not to have, to not review this stuff in order to come to your conclusion. Wow, that really looks bad, right? So as slick lawyering, it may sound pretty good. But if you actually just continue down this path, just think about, you're right. I can list a million things that they didn't know and they didn't have. The question is not how much information they did not have. The question is, why is that information important to them? Why should that information be important and material in order for them to come to their conclusion? So they didn't know that Karen Reed told people, I hit him, right? They didn't know that. Now, is that going to somehow magically change the science and physics and mathematical equations that they're dealing with? Oh, well, if you would have told me that she said she hit him, then all of a sudden the physics makes sense, right? It obviously doesn't work. If you're working in the world of physics and mathematics, then this information doesn't really change, doesn't change your opinion. It shouldn't have any effect on your opinion. Whether Karen Reed said that she hit him, and whether there's a DNA report that showed that there was one piece of hair from John O'Keefe that ended up on that vehicle somehow. Why should that change the physics? It doesn't change the physics. It doesn't change the math. Oh, now that there's a hair there, you're right. Now this whole equation that I did, if I would have only known about that here, that would have completely changed this entire mathematical equation. Obviously not. So what information do you actually need as an accident reconstructionist to be able to run a reconstruction using math, using physics, using everything that you've known to be able to run this reconstruction? So let's just go to one of the most popular arguments that they use. And okay, because I think the fact that they didn't know what Karen Reed said, that I hit him, it to me, again, doesn't change anything about the math and the physics and the science. But let's go to another real favorite argument that I keep hearing is that, well, they didn't actually see the actual vehicle. And again, if you're a layman, this can really work on you. This is why lawyers do it, by the way. These type of arguments can work on you. But if you actually think about this logically, it doesn't add up. Okay, so they didn't actually view the Lexus, and they had the opportunity. They could have gone and seen that Lexus. So I'm going to ask you, if you have pictures and you have reports of exactly what the damage was to the vehicle, just tell me, why do you actually have to see the vehicle? I'm running an equation here. I see what the damage is. I know that there's a broken taillight. I know that there's 43 pieces of broken taillight. I know that there's some scratches on the side of the car, and I see pictures exactly where all the damage is. Why do I have to actually go down to the car and see it? And in fact, there is a specific science that accident reconstructionists use, which is what Dr. Wolf testified to. It's called photogrammetry. And this is what reconstructionists do. They use pictures. It is a science. This is what they're doing. They don't have to actually see the vehicle. And they've said it a number of times during their testimony that it wasn't necessary for them to see this vehicle. So now why are they saying that? Because somehow they're also hired by Karen Reed privately to say things that actually are completely not true? No, because they're actually telling you what the truth is. They don't need to see the actual vehicle. But people will still continue with this whole argument that, well, they had a very limited amount of information. If you think about what they had, that's all they needed. They had the information, they had the damage to the vehicle, and they had the damage to John O'Keefe. They had a number of reports, autopsy reports, and some of the CDR record, and they had enough, what they felt as an independent body, to actually do a reconstruction. So again, it's really grasping at straws to be able to say this type of argument where the experts just didn't realize themselves. They just didn't realize themselves that this other information would have completely changed the entire equation and their entire conclusion and analysis, and therefore we should completely discredit these experts. And like I said in the beginning, this type of argument where you can say that the experts are biased, they're prejudiced, they're trying to not look at certain information, yeah, it's a better argument when they're actually hired by a specific side. But when these are just independent people trying to, experts that were hired by an independent agency to come to a conclusion, and they don't really care what the conclusion is, do you think they're just going to start cutting corners and say, I don't want to see that information? Why? What's their bias? What's their motive to lie and tell people, well, we don't really need to see the car, but really they did, and broadcast to the entire world of accident reconstructionists that they're saying something that's so obviously wrong about accident reconstructionists, and just all the Commonwealth has to do in the next trial is bring up an accident reconstructionist and say, of course you have to see the actual vehicle. Well, now their job is very easy. So if the next trial, maybe we'll see this. Maybe we'll get some sort of accident reconstructionist to say, you absolutely 100% have to see the vehicle. But until that happens, and that didn't happen yet, definitely not in this trial, until that happens, I don't think that this really takes away at all from their credibility. All right, so let's continue.
Not review the state police reconstruction report, which is exactly what he was doing.
Right, and then there's another one about Dr. Wolf not reviewing Trooper Paul's accident reconstruction report, which is kind of laughable, okay? Because Trooper Paul is like in first grade compared to what these guys are. So it's like, oh, you don't look at his drawings and his sketches. How can you actually come to a conclusion that's credible? I mean, not the greatest argument there.
And he did not know that the human hair found on the bumper was consistent with John's DNA. Those are all pretty important information for the totality of the circumstances here. Wolf also said that the supposed strike between Karen's car and John's parked vehicle, this is important, would not have caused any damage to Reed's taillight. So again, I saw a lot of people after this particular testimony go on social media and say like, oh my goodness, I'm totally convinced of the defense's case because of what Dr. Wolf had to say. I'm not going to lie. I don't see what that is, because on cross-examination, everything fell apart in the sense that he was able to reach what the defense wanted him to say with almost no facts of the case. And
did you hear that? Like almost no facts of the case. Almost no facts of the case. That's how they were able to come to their conclusion. And remember, what is the scope of their work? What's the scope of their work? The scope of their work is, here are the injuries, here's the damage to the vehicle, you figure out how this happened. Now, what more information do you need? If they needed more information, they would have said, I'm sorry, we cannot come to a conclusion because we need more information. That is what happens when you're trying to hire an expert and you don't give the expert enough information. Now, if they didn't do that, which they didn't, and you look at what they actually had with them, this isn't so limited. They had no information at all. They're missing so many facts of the case. Why? Which facts of the case were just so many facts of the case that they needed? The fact that she said, I hit him. The Trooper Paul's drawings and his analysis, and the fact that there was a here on the car that's somehow going to change the physics and science of how this accident happened. I mean, just if you use some basic logic, this argument completely falls on its face.
And we are not looking in a vacuum. Right? He wasn't told about the DNA, the hair, where he was standing. He essentially is saying everything on cross that the prosecution's forensic experts are saying. He's agreeing with them when given all the facts. And he's facing it for the first time.
I don't know how she came to that conclusion, that he is saying everything that the prosecution's experts are saying when given all the facts. Did I miss something in that trial? Did I miss something? I mean, go ahead and rewatch that and tell me where he agreed to everything that Trooper Paul said when given all the facts. I didn't see it.
First time. He didn't know these things ahead of time. He testified on a set of hypotheticals given to him. And those hypotheticals are just that, hypotheticals without the real life evidence that we have in this case.
Okay, so first of all, just a little note about hypotheticals. Okay, hypotheticals is or are what you do with experts. That's what experts are able to help you with. They're able to help with hypotheticals. You're allowed to ask hypothetical questions of experts for that reason, because experts have that specific knowledge to be able to plug in their expertise. In that hypothetical, this result would happen. In that hypothetical, this would be the result. That's what experts can do. That's why we call experts. Now, you're right. In this case, they weren't completely given hypotheticals. They were given information, the pictures, the damage to the vehicle, the damage to John O'Keefe, and some other data that they were necessary for them to run some sort of analysis. And they were asked, figure out how this happened. Do a reconstruction where the damage to the vehicle and the injuries to the person's arm equal each other. Do whatever you want. Any analysis that you want to figure out how these two things mix, how these two things equal each other. And they weren't able to do that. So I don't know what part of hypothetical that is. That is exactly what these reconstructionists are hired to do every single day. Figure out how this happened. So, all right.
But I do think it's really important, and this is pretty bad for the defense, when he says that, okay, whatever you believe of whether Karen hit John, that taillight was not broken when she hit John's car.
Now, that is the one part that did hurt the defense's case. Absolutely. That hurt the defense case when he said that backing up into John O'Keefe's car would not have caused the damage that he saw to that taillight. Okay, so if the defense was completely relying on that to win them the case, then you're right. They would have lost the case because that's what Dr. Wolf said. That would not have caused the damage to the taillight. Although that wasn't the defense's theory is not limited to that one little backup that maybe that's what caused the shattering of the taillight. There could also be a lot of questions about that car being in custody and what was going on with that car while it was in custody. So yes, they did show that there was some sort of interaction between John O'Keefe's car and Karen Reed's car. Maybe that started the crack or whatever. But you're right. That's definitely a fair point that they made, that Dr. Wolf definitely debunked any theory that backing up into John O'Keefe's car is what caused the extent of the damage to that taillight. So that is a point that for the Commonwealth.
Which is obviously what Karen Reed's explanation is of how her taillight got broken.
And I'll say a couple things about this guy. Number one, he definitively proved that John was not struck by the SUV in a way that no one is saying he was struck.
Which I really don't follow that. He definitively said that John O'Keefe was not struck in a way that nobody said that he was. Okay, so if you can unpack that, what I think he's trying to say is that Dr. Wolf's testimony about these options, these hypotheticals could have never happened. And well, nobody said that that's what happened. That wasn't even the Commonwealth's theory. So I think that's the argument that he's trying to make here, that everything that Dr. Wolf is saying did not happen in this case, no one said happened. And that's what he's arguing. However, if you continue with that, right, you say, well, Dr. Wolf said this was not a head-on collision and this was not a side swipe. Well, then please, pray tell what the Commonwealth's theory is. This wasn't a side swipe and this wasn't a head-on collision. So then what was this? Was there any interaction? I mean, what theory is he thinking that the Commonwealth is saying that Dr. Wolf did not debunk? Completely debunked the side swipe and he completely debunked the head-on. So what are you left with? What theory did the Commonwealth have left after there's no interaction between this car and John O'Keefe?
I mean, he demolished that theory. So
that's literally what we call a straw man.
Yeah, I mean, that's exactly what it was. He destroyed that, he burned that straw man to the ground. So we know that didn't happen. The other thing,
right. So again, I mean, I really don't know what they're talking about. I don't know if they really. I mean, if you watched Dr. Wolf's testimony, it was clear that this was not an interaction at all. There was no interaction between John O'Keefe and that car. I mean, physically, it can't be. Scientifically, it can't be explained. So it's not a side swipe and it's not a head-on collision. So I don't know what straw man they built that is now burned to the ground that doesn't also destroy the Commonwealth's case. So I really don't know what they're talking about. Maybe some of you can help me out.
People were so impressed by the cannon he built. He built a cannon to prove something that doesn't even matter. I mean, I don't know. Could John have thrown the glass at the taillight and shattered taillight? Maybe. Maybe that's what inspired her to back up at 24 miles an hour and hit him. What would have been so much more valuable is if the FBI, in its infinite wisdom, when it decided to hire this person, had given them all the information and said, hey, here's all the information. Given the fact that we have a 24-mile-an-hour backup, given the fact that we have the DNA and the broken taillight pieces and all this other stuff, can you create a reconstruction where her SUV hitting a person could have caused the injuries he had, caused the pattern of distribution that we see, and caused the damage on her car. And maybe he would have done it and either said no.
But that's exactly what they gave him. He just said it would have been so much more valuable if they would have given him this information that we have a car that's backing up, that's injuries to the car, damage to the car, injuries to the person, figure out how this happened. That's essentially what they did. That's exactly what they did. So what information are you talking about that they did not give them, that they should have given them, that you would have said would have been so much better? And just another thought here is that in case you want them to say, here, this is the Commonwealth's theory here, test this out. Maybe this is maybe this is the case that they're making here. Why don't they say, hey, this is what we are going to be presenting in trial. This is what the Commonwealth's theory is. And again, they're not hired by the Commonwealth, so whatever. Let's just assume that this would be a little bit that the FBI and DOJ would be interested in. Okay, so do this theory, run the test on this theory of the Commonwealth, and come back with whether this is yes, a possibility, or no, a possibility, right? I mean, wouldn't that be so much more helpful? So what I would say is no, that's not helpful, because then you're saying what the conclusion is or what they believe it to be, and now you're trying to fit in your science to that theory. No, I don't think that that's a great idea. I think what's a better idea is you give them information without telling them what the conclusion is, without telling them what other people think happened here. I think that's much more of a more honest and truthful way to get to the truth, is by saying, look, we're not going to taint you with any of our theories about what happened. This is the facts. Here are the pictures. This is the damage to the vehicle. This is the damage to John O'Keefe. We'll give you as much information as you need without telling you theories of the case. And now run your analysis and figure out any possibility, any theory that you want. We're not gonna strong arm you into any theory. You're the scientist. You come up with any theory that fits. And if they come back and say, I'm sorry, there's no theory that fits, then that is much stronger. If you want an analysis, if you want an honest analysis done, that's what you do. You don't tell the person that you're asking to do an expert analysis, if you really want it to be objective, 100% objective. If you're an insurance company, you want to deny a claim, right? So you send it to an expert and you say, hey, we'd really like for this claim to be denied. Run your analysis. Well, of course, you kind of told them what you want, right? So it's not going to be as honest. But if you're not an insurance company, or if you're not being hired by any side, and this is just experts, and say, hey, here's some information that you need. Let me know if you need any more information. This is the information that you need. If you need, and run your analysis and let me know all possibilities that these results that can result from this. And I think that that's much more honest. And they've done that, and they still can't figure out a theory. The only theory that they can come up with is that John O'Keefe threw this glass at the taillight. That was the only theory that Dr. Wolf can come up with, how this damage happened to the vehicle, to the taillight. That was the only circumstance that he can come up with, only theory. If you would have said, well, try to fit it into this theory, that's not as honest. So, no, I don't agree with this at all.
I can tell you, based on all the facts, that didn't happen, which would have been incredibly powerful, because then he would have disproven the actual theory of the prosecution and not another theory. Or he could have said, look, the variables are just too many, and I can't tell you that happened, which would have been great for the defense, because the defense could say, look, there's doubt for you. I mean, you just can't prove this. Sorry.
That's literally what happened. That's literally exactly what happened. He apparently has some sort of theory that we never heard of, that the Commonwealth was trying this case on, that was not debunked. So if you know what he's talking about, because the side swipe was clearly debunked, the head-on collision was clearly debunked, and Dr. Wechsler, which he's going to get to soon, clearly said there is so many infinite possibilities how this could have happened that there's just no evidence to support one way more than the other. I mean, that's exactly what the expert said. And he's saying, oh, if they only would have done that, then they would have been able to prove that this was, then the defense would have been able to show that this is not beyond a reasonable doubt. That's exactly what happened.
The way it would have had to have happened for John to have been injured the way he was, it cannot be recreated. So you're just going to have to go on faith. When you're going on faith, that's an acquittal. Or maybe if he'd actually put all those variables in, he would have created a scenario by which this could have happened. And you would have seen what you saw. And that would have been really powerful evidence as well. But instead, we have him building a cannon so he can fire a glass into a car. I mean, I can tell you, if you throw a glass at a car hard enough, it's going to shatter the taillight. I don't need a cannon for that. So I'm not sure why we're building cannons. It's like...
It was a sideshow. Honestly, it was a shiny sideshow that like distracted people from... It did nothing for his testimony. But it was a cannon that people could talk about.
And people were so impressed by the cannon. They're like, he built a cannon. Okay, great. I mean, what if he could have built a trebuchet for all I care? It doesn't prove anything if it doesn't have anything to do with the case. And just...
Well, okay, let's just talk about the cannon, because I don't know why we're wasting time on the cannon, but let's talk about the cannon. So you have someone who's trying to do a reconstruction, right? They're trying to figure out how did these materials, a drinking glass, a human being, tail light, which possibly could have been backed up at a certain speed. How could all this interact with each other and create this damage, right? So how are you supposed to reconstruct that without building a cannon? Just anybody have any ideas? Okay, well, one way to do it in an uncontrolled way is to have somebody throwing repeatedly a drinking glass at the back of a model of a whatever you're going to create to reconstruct this taillight. So I guess that they're suggesting that, why are you building a cannon? What you should do is have somebody standing on the side who can't control his speed, throw it at the taillight, and see if you can get that type of damage. And I guess on the side, you have to have somebody with a radar gun also. So that's probably not a great way to test this. And then you're going to tell the guy, okay, you only threw that at 15.8 miles per hour. Now we need you to jack it up and throw it at 17.7. I mean, like, that's unreasonable. So, yeah, I think that the cannon was just the only way that they can do this in a controlled environment, knowing how fast they're going to be throwing that, how fast this drinking glass is going to be aimed at the car. Otherwise, that's the point. That's exactly the point, is that they don't have any other explanation of how this damage got to how this vehicle was damaged. There is no other way, because every other conceivable option was debunked already. So this is their last resort. Okay, maybe he threw it. Well, how do we reconstruct somebody throwing a glass and do it at these different speeds to be able to lock down exactly what speed it was going and then be able to actually run this reconstruction? Well, I guess you got to build a cannon. Yeah, that's what you got to do. So, I mean, I'm not sure what exactly the issue here is. And that's exactly proving the point here, is that they were so out of options that this is the only last resort option how they can reconstruct this damage to the vehicle.
I don't know. I mean, to me, the cross-examination was one of Lally's best. He ended on this cross because they didn't put on any rebuttal witnesses, which I think is a mistake. I wish they had have. As we talked about, I wish some of those witnesses that came in the case in chief had been held on to, or had just been called back. You could have called back some of those witnesses to testify to a few of the things they testified.
I mean, really, I don't think, I'm just going to say my opinion, I don't think this was Lally's best cross-examination. Okay, I'm going to have to take issue with that. I don't think that at all. I think the experts completely held their own. They said very clearly all this information that Lally asked them that they didn't have. They said very clearly they didn't need to have. So no, I don't think it was a shining moment for Lally when he was cross-examining these witnesses.
To rebut some of this, and whether to call rebuttal witnesses is always a tough call, especially when you've had a trial going on as long as it has, and the jury can see the light at the end of the tunnel and they just want to be done. But I feel like this was a case that probably some short rebuttal witnesses could have been really powerful, and we didn't have that. And that brings us to the final witness of the defense and of the trial, Dr. Rentschler. Now, Rentschler was another ARCCA reconstructionist specializing in things like kinematics. He said that the injuries to John were inconsistent with a vehicle strike. And this was a good way for the defense to end. And it is what a lot of people took away from their presentation. Even now, you hear people say this is one of the most convincing witnesses to them, because his conclusion is one that is inconsistent with Karen Reed being guilty. But here's what I want you to do. Go back and listen again. Listen to what he actually says. Like Wolf, Dr. Rentschler is describing a strike that is not the state's theory of the case. For instance, he talks about,
And again, apparently he's got some theory of the case that we've never heard of. Because again, both Dr. Rentschler and Dr. Wolf both clearly said that this was not a head-on and this was not a sideswipe. So I don't know what theory there is left, quite frankly.
It's about how if John's head was struck by the vehicle, you would see other injuries, worse injuries, which is true. But that is not the prosecution's theory. This would seem to be important, though, because Rentschler says that...
Yeah, and again, they're bringing up all these crazy theories just for the sakeness of completeness. Just for the sake of completeness. Okay, let's go crazy here. Did the car back into his head? No, that's not possible either. Did the car back in sideswipe his arm? No, that's not possible either. Okay, is there any other conceivable way that this theory could have happened, that the Commonwealth theory could have happened? And essentially what Rentschler and Wolf both said, no, it just doesn't. You can't deny the physics and the science and the math behind this. I mean, if you want to live in a make pretend world where we just kind of ignore the science because it's, we don't want to believe a conspiracy theory, then and ignore the science. Okay, everybody has their choice of what they want to do. I think most people would rather trust the science from objective, independent experts, and that's what we have here. So again, he's got some theory of how this happened without the Commonwealth ever talking about it. So
falling backwards was not enough to produce the damage to John. So you sort of have the situation where it's like, if he was struck by the car, there'd be more damage. If he just fell, not enough damage. So we must have something else must have happened. But the thing about that is, if you watch the cross, a lot of this stuff falls apart. On cross, Rentschler acknowledges that, in fact, John's skull fracture is consistent with slipping and striking his head. And then, in fact, there were almost infinite possibilities for what could have caused his injuries. In fact, Rentschler would say, quote, "We don't really have enough evidence to determine exactly what happened." Now, that's interesting because much like Wolf, Rentschler was unfamiliar with most of the evidence in this case. He didn't know that DNA was found on the taillight. He did not review the reconstructionist report from Trooper Paul, or the forensic reports, or the DNA reports, and he didn't go to view the SUV physically, which you think would be something you'd want to do if you want to say that the damage to that car is inconsistent with a strike, and that a strike couldn't have killed John.
Yeah, and so again, we're going through the same circle of well, he didn't have, and they keep saying most, like they didn't have most of the information on this in this case. Yeah, I guess they didn't watch all 27 days or 30 days of trial. They don't have all the transcripts from all the witnesses and all that stuff. The question is, what does that have to do with their analysis? If it doesn't actually affect their analysis, so then it's ridiculous. We already spoke about this. But then, even just in case you want to be one of those people who say, well, they didn't have enough evidence and therefore they are completely debunked, not even reasonable doubt. They weren't even able to create reasonable doubt, these experts. They're just completely unreliable 100%. But then Rentschler said, even after becoming familiar with more evidence of this case, it still doesn't change the science. And that's why he kept saying, you can't change the science. You can't change the physics of this case. So whether there was a hair on that car, whether there was a DNA report that came back positive for a hair on that car, whether we hear that Karen Reed said, I hit him, whether they would have actually viewed the real Lexus and confirmed that this was the damage to the Lexus, it still doesn't change the physics. It still doesn't change the science. That's what they said. That's what Rentschler said. So even if you want to completely ignore all of the logic behind this and then just say, well, they were missing some evidence and that's it. And you get taken over by this lawyering, oh, you're missing the evidence. Then he said, yeah, when I became aware of the evidence, I still didn't change my opinion. Well, there goes that then.
And the report he did issue appears to have been premised on John wearing a jacket at the time, which, as we all know, he was not wearing, a fact that Rentschler was unaware of. And look, this.
Yeah, and then when he said, okay, but even now that I'm not aware of that, it still doesn't change the opinion. Like, yeah, this was brought out, cross-examination. Oh, were you aware that he was not wearing a jacket? Yeah, it didn't matter. Oh, okay. Well, I'm still going to believe that makes a difference. So.
This goes back to sort of a fundamental thing. Jurors, people listening, You hear expert and you think, well, if it's an expert, what he says is gospel, right? I mean, that's almost the way people approach it. And that's not what you need to do. Think about what they say. See if it lines up with the facts of the case, not just some world out there, but the facts of the case. Think back to the Scott Peterson case. They're doing an experiment with a boat that's completely different from the one Scott Peterson was in. And they say you couldn't do it because if you did it, the boat would flip over. Well, how helpful is that when it's not the same boat? How helpful is that to you deciding whether or not Scott Peterson could have done it? In this case, you have a situation. Take the dog bite expert. Are those marks on John's arm consistent with some dog bites? Absolutely. You can come up with dog bites that are consistent with those marks. Are they consistent with the dog bite that has been posited in this case, in this circumstance, in this scenario? I don't think so. Similarly, when you hear Rentschler, he's talking.
What about those dog bites being consistent with a strike from a vehicle? Has anybody at all testified to that? Oh, yeah, there was Trooper Paul. Oh, okay, fine. So, well, Trooper Paul is an expert, I guess, if you want to call him an expert. So then I guess they're asking, well, you should ignore Dr. Marie Russell about that these injuries are, the scratches and abrasions on his arm are from a dog bite because it just doesn't equal the facts of this case. And therefore what? And therefore we should believe who? Believe that these marks are from a car? Who testified that they're from a car? Which expert testified that? Oh, Trooper Paul, who's had exactly 0 patients who's ever treated for abrasions to their arm. That's what we're supposed to trust in this case. So, like the argument's it's not working out really.
Talking about how this strike is inconsistent. Is it inconsistent with most car strikes? The injuries on John, are they inconsistent with most car strikes? Absolutely. Of course they are. But the prosecution is not suggesting a standard kind of strike here. Something weird happened that night. Even Karen Reed told people that she thought she only sideswiped John, that it was sort of a brushing blow. We don't know exactly what happened that night, and it's an advantage to Karen that it wasn't a standard strike by a car. But just because Rentschler tells you this isn't consistent with your average car strike doesn't mean that Karen Reed's SUV didn't back into John that night.
But Rentschler didn't say that this is inconsistent with most car strikes. He didn't say that this is inconsistent with an average car strike. That's not what he said. What he said is that it's inconsistent, period. This is inconsistent. This whole theory that there's any interaction between the car and John O'Keefe, which results in this damage to the car and this damage to John O'Keefe, that's inconsistent. So other than completely changing Rentschler's testimony and then arguing, well, he's still left open an option. If that would have been an option, then Lally could have said, is there any way that this could have happened? Any way at all? Even if it's not your average and even if it's not most, is there any way that this interaction could have happened in the slightest? And the only way that you'd be able to say is that, yeah, maybe it was a nudge and that didn't cause anything. And then he ended up stumbling backwards, hitting his head, and then some dog came and scratched him. Yeah, I guess that's a possible theory, but then that would completely acquit Karen Reed also. So there actually is no theory that was put forth by the Commonwealth, which makes Karen Reed guilty, which also shows that there's any sort of consistency between the car damage and John O'Keefe's arm. That's exactly what these experts testified to. And for you to say that that's not what his testimony was in most cases, on the average, no, it was very clearly this interaction didn't happen. At least the interaction that caused these wounds, these abrasions to John O'Keefe's arm, it didn't happen. So unfortunately, maybe for you, I was not convinced by the arguments by the prosecutors podcast, and the ARCCA experts were very, very credible, largely untouched during cross-examination. The only little bit of cross-examination that they got, only points that they scored was number one, that the backing up into John O'Keefe's car didn't really cause the damage to the taillight, which is agreed upon. That I agree about also. That's a good point for the Commonwealth. And this other idea that they didn't actually visit the vehicle itself, and whether you want to put any importance on that when these independent objective experts are saying that it wasn't necessary for them to conduct their analysis, and you just want to be smarter than the experts with you having no expertise, then that's the decision that you're going to have to make. But for me, I have not seen really that this cross-examination did anything to the experts. The experts were extremely solid. They were very clear on their testimony. They had all the information that was necessary. Yes, they didn't have a lot of other information that's irrelevant. So if you want to start talking about all the information that was irrelevant to their analysis that they didn't have, go knock yourself out and put it in the comments. But the information that's actually relevant to their analysis, they had, and they had plenty of it. And that's why they came to their conclusion. So that's going to be it for now. Okay, that's going to be the end of my review of the Prosecutors podcast. And again, like I said, if there's other attorneys that are having some other ideas or other analysis why they believe that Karen Read should have been found guilty in this case and why the evidence shows that, and they're not going to start changing around what the witnesses are actually testifying to, then I would love to see it. So please send it to me and I'll be able to review it. All right. Well, that's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.